Hello viewers, today we are going to talk about mosques, and the objectives for today's lecture are to study the institution of mosque, to pursue the objectives of a mosque, to understand different types of mosque, and to analyze the requisites of a mosque. Now let's start with the introduction. Muslim law recognizes various institutions for religious purposes. Some of these important institutions are mosque, khanqah, dargah and imambara. The dedication of any property to these institutions constitutes a valid waqf. This kind of dedication is considered to be made for the religious purpose in accordance with Islamic policy. Mosque is a place where Muslim community perform the devotions and offer religious prayers. It is different from the other institutions. Dargah means a threshold. Under Muslim law, this term is used to denote a shrine or the tomb of a Muslim saint. Religious prayers are also offered here. Khanqah is an institution where Muslim religious instructions are imparted. The religious head of a khanqah is called Sajjad-e-Nashin and the followers are known as murids. Imambara is a separate area in a private building set apart for the performance of certain private religious ceremonies. It is particularly established by the members of a Shia sect for the performance of religious ceremonies at Muharram and other religious occasions. It is not a public place of worship like a mosque. Now let's discuss what actually mosque means. The word mosque or mosque is derived from Arabic word masjid, which means a place of worship. The word entered into English from Italian word moscia and Spanish word mezquita, which also means place of worship or prostration in prayer. A mosque is a place where all Muslims gather to offer the prayers and to worship God. Any Muslim belonging to any sect or school can enter a mosque to perform his devotions in accordance with the practices followed by his own sect. It cannot be reserved for the exclusive use of persons belonging to a particular denomination. In the case of Ataullah versus Azimullah 1889, the Allahabad High Court held that a mosque dedicated to God is for the use of all Muslims and it cannot be dedicated for the exclusive use of any particular sect. The decision was also referred by the Privy Council in Fazl Karim versus Mola Bakhsh case. No Muslim can be denied from saying his prayers except for creating disturbance or annoyance to the members of congregation or for misbehavior. Mosques are a form of waqf. When a building has been set apart as a mosque and public prayers are once said there with the permission of the owner, it is enough to create a waqf. Waqf means dedication of some property in the name of God for some pious, religious or charitable object. So a valid waqf may be created by dedication of property to establish a mosque or in favor of an already established one. Now let's discuss legal status of a mosque. Mosque is not a jurisdict person. It has no capacity to sue or to be sued in its own name. The Lahore High Court attributed the juristic personality over the institution of mosque in Mola Bakhsh versus Hafizuddin case, but later on the Privy Council took the contrary view in Masjid Shahidganj case. The court held that the suits cannot be brought by or against mosques, for they are not artificial persons in the eyes of the law. Mosque is not a juristic person. In Muhammad Shafuddin versus Chaturbhuji case, same opinion was reaffirmed by the Rajasthan High Court. The mosque do not possess any juristic personality. Now the second aspect is requisites of a mosque. For the consecration of a mosque or to recognize a building as a mosque, following essentials are required. First, declaration of intention to dedicate the property. To dedicate a property for the purpose of a mosque, the founder must declare his intention to dedicate the property. No specific form of declaration is required. It can be deduced from the express or implied conduct of the dedicator. In Mahir Hussain versus Ali Muhammad Jalaluddin case, the Bombay High Court has held, when once a building has been set apart as a mosque, it is enough to make it a waqf if public prayers are once offered there with the permission of the owner. But though a declaration of dedication and completion by some sect giving practical effect to it are essential, it was not always necessary that there should be any direct evidence of these things. Dedication may be inferred from long user as waqf property. Second, founder must divest himself of the ownership of the property. The founder must divest himself completely from the ownership of the property dedicated to the mosque. He can deliver possession of the property to mutawalli or an imam in order to divest himself. Dedication may take place even without the actual delivery of possession, if the Muslim public is permitted to offer prayers at the mosque. This permission will amount to a valid dedication of property and divestment of the founder from the ownership of the property. Broadly speaking, the founder may divest himself of the ownership of the property by two modes. First, by delivery of possession of the property to imam, or by allowing the public to offer prayer at the mosque. Third essential is, building must be separated from the other properties of the owner. The building which is dedicated as a mosque must be separated from the other properties of the owner. There must be actual and visible separation of the dedicated property. Any kind of accretions, additions, or alterations in the properties attached to the mosque constitutes a part of the mosque. The money given at the mosque for repair or maintenance and every kind of gifts offered at the mosque constitutes a part of the mosque properties. Fourth, separate entrance to the mosque. To constitute a mosque, the founder must provide a separate way to it. It should be open for the public. Any member of public belonging to any sect or school of Muslims may go to the mosque to offer prayers. It cannot be reserved for any particular sect of Muslims. Fifth, public prayers must have been performed at the mosque. The dedication of the property to a mosque is complete by a formal declaration accompanied with the permission to the members of public to offer prayers. This essential is also emphasized by the Bombay High Court in Mahir Hussain versus Ali Muhammad Jalaluddin case. The court observed that holding public prayers with the permission of the owner at a building set apart as a mosque is enough to make it a waqf. In Musahib Khan versus Rajkumar Bakshi case, the Awadh court has held as follows. Even if a mosque, that is a building having the appearance of a mosque, is built in a place which is not enclosed, that is not situated in such a man's house, something more than the mere appearance of a mosque are needed before it will become entitled to be treated as a mosque for all time. There must be proof of dedication, of permission, or of user, such as by the saying of prayers in congregational manner. The mere construction of a mosque in a private house does not make it a mosque in the sense of a public place of worship. So the offering of public prayers at the mosque is an essential requirement. If a mosque is built inside the house only for the use of the family, it does not become a public mosque unless permission is granted for public prayers. Sixth essential is long use of the property as place of worship. When the prayer are regularly offered at a mosque existing from a long time, it will constitute a presumption that dedication for mosque is complete. Now, the long use of the property as a place of worship has converted it into a mosque. Mahir Hussain versus Ali Muhammad Jalaluddin case is related to such kind of dispute. In this case, a tomb of Pir Mushayyak was constructed nearby the mosque as well as the tomb. The dispute was raised by the Mu'min sect of Muslims, which claimed that property of the tomb was dedicated by the devotees of the Pir and it is not a part of the mosque. The Bombay High Court held as follows. Where for a considerable number of years the public have been offering prayers in a mosque close by a tomb of a Muslim saint, and an annual urs attended by persons belonging to Mu'min group of Muslims has been regularly held, it must be presumed that the mosque and the tomb have been duly dedicated and have become waqf by user, and the presumption might fairly be extended to other buildings and land enclosed within a compound wall, which might be regarded as appurtenant to the tomb. Similarly, in Miru versus Ram Gopal case, the Allahabad High Court supported the same view. The court held that where there has been a mosque for a long time and the terms of the original grant of land cannot now be ascertained, there will be a presumption that mosque has become waqf property. Now the property has got converted to a mosque by its long user as a place of worship. Now let's discuss objects of a mosque. The main objects of a mosque are: first, to offer prayers. The main objects to establish a mosque is to provide a place to offer religious prayer. A mosque is dedicated to the whole Muslim community. It cannot be dedicated to the Muslims of any particular group or sect. A member of any denomination can offer his prayers in any manner followed by him, provided his method should not disturb others. To maintain the sanctity of the mosque, he can say his prayers at the back of the congregation. There is no mandate to follow any particular form of congregational prayers practiced at the mosque. Usually offers 5 daily prayers, Friday prayer and optional prayers. Second, teaching the Holy Quran. A mosque also imparts the teaching of Quran. I'tikaf is a practice in which at least one Muslim from the community must participate. To perform i'tikaf, a Muslim is required to stay within the mosque for 10 successive days and spend these days in worship or learning about Islam. The mosque hosts i'tikaf during last 10 days of Ramadan. Third object is appointment of prayer leaders or imam. A prayer leader, that is imam, is appointed in the mosque to lead the congregation during prayers. The imam must be a person of high character and may be appointed in the following manner. In a mosque constructed and maintained by the Islamic government, the imam is appointed by the ruler. And in a private mosque, appointment is made by the members of congregation by means of majority voting. It is not a hereditary right to become an imam because imam must be a person with special qualities and special knowledge of the religious scriptures. If the Imam acts in violation of any Islamic principle, then he can be replaced with another Imam. Fourth, charity. Mosque provides facilities to poor and needy people. It makes arrangement for the help of infirm or disabled persons, anyone facing financial hardship, etc. As per the Islamic principles, the Muslims are required to donate approximately 1/40th of their wealth to charity as zakat. Mosque, being the center of Muslim community, is the place where zakat is given, and the persons in need collect it from there. Mosque also collects a special donation before Eid ul-Fitr. This connection is used to help poor Muslims to celebrate the occasion and attend the prayers. Fifth, instructions for concentrated worship. In accordance with Islamic principles, mosques institute a number of rules in order to keep Muslims focused on worship of God. It is supposed to offer prayers with full concentration and respect. Loud talking is prohibited inside the mosque. To disturb a Muslim in prayers or walking in front of such person is considered as disrespectful. The walls of the mosque are simply constructed and have few items over it. Only some Islamic verses are usually written on the walls of mosque. These rules are followed to avoid any kind of distraction during prayers. Sixth object is to look after the cleanliness. All mosques have their cleanliness rules as it is an essential part of worship. A Muslim is required to cleanse himself before offering of prayers. This actually is known as wudu. Every person entering the prayer hall of the mosque have to take care about the cleanliness even if he is not intended to offer prayers. It is also prohibited to bring shoes inside the prayer hall. Seventh, directions for decent dress-up. As per the Islamic requirements, the mosque insists that Muslims should wear decent clothes while coming to the mosque. Women also have to wear loose clothes covering their body up to wrist and ankles. They should also cover their head. This kind of robe worn by the females is called as burqa. The dress should be loose to such an extent that it should not reveal the shape of the body. Eighth, gender separation. The Holy Quran does not depict anything about the matter of gender separation in the mosque, but conventional rules have separated men and women. Women are usually allowed to make rows behind the men. The traditional posture for offering prayer includes kneeling on the floor, touching head to the ground. It is uncomfortable for the woman to say the prayers in a mixed gender prayer, and it is also distracting for the men. So, the women are usually asked to occupy the space behind the men. Some Muslims also insist that Prophet Muhammad, peace be upon him, preferred women to pray at home rather than at a mosque, and they cite a hadith in the support of their argument, in which Prophet Muhammad, peace be upon him, said, "The best mosques for women are the inner parts of their houses." He has directed the women to offer prayers at home only to save them from any kind of harassment. Despite that situation, keeping in mind the fact that women were more devoted to visit the mosque, it was started by Prophet Muhammad, peace be upon him. He asked the Muslims to allow the women to enter into the mosque. Now, let's talk about the types of mosque. First, public mosque. A mosque where a Muslim of any sect or school or subsect is entitled to perform the prayers as per practices of his own sect is called a public mosque. No Muslim can be denied from entering in a public mosque as it cannot be reserved for a particular sect of Muslims. When a property is dedicated to the mosque, it no longer belongs to the owner, but becomes the property of God. In Muhammad S. Labai versus Muhammad Hanif case, the Supreme Court observed that once the founder builds the mosque and prayers are being offered, the site and the mosque becomes a waqf property and the ownership of the founder is completely extinguished. From the above observation, it can be concluded that a building can be called a public mosque if the following essentials are present. First, building must have separated as a mosque from the other properties of the founder, and the founder must have permitted to conduct public prayers at the mosque, and it must have been said, and long user of the property as a place of worship by public. A mosque having these requisites may be recognized as public mosque. Now, before discussing the second type of mosque, let's first know about the manner of prayer. A public mosque does not belong to any particular sect. Any Muslim is entitled to enter the precincts of the mosque to offer his prayer. He cannot be denied to visit the mosque on the ground that he belongs to a different sect or denomination of Muslims. Every Muslim is permitted to offer his prayer in accordance with the method or rituals of his own sect. In Muhammad Wasi versus Bachchan Sahib case, the Hanafi Muslims of Mahmudabad, Uttar Pradesh, filed a suit against Shiite Muslims to restrain them from following their own method and ceremonies of prayer in the mosque. The court refused to grant any kind of restraint and held that mosque is dedicated to all the Muslims belonging to any sect or school. They have a right to offer their prayers in any manner recognized by their sects. Mosque cannot be dedicated for the Muslims of any particular sect or subsect. Third, no person can alter the form of congregational prayers usually offered at the mosque. He can follow the manner of prayer followed by his school in accordance with the Islamic principles. Fourth, the object of dedication cannot be changed. The change of beneficiaries is also prohibited. Fifth, if a Muslim is prevented from entering into the mosque, he can claim his right through the court. In a public mosque, nobody can claim that the others should not follow their faith and manner of prayer. Now, second type of mosque, private mosque. A mosque constructed within the house of person, having no outside entrance and where the general public is not allowed, is called as the private mosque. Although the Muslim law does not permit to reserve a mosque particularly for the members of any denomination or sect of Muslims, but it can be for a particular family or certain specific group of persons. In Abdul Baqi versus Chaitanya case, the inmates of the police lines were managing the mosque situated within the compound of police lines. Only those persons were allowed to enter the mosque that could enter the area of police line. The general public is allowed to enter only on some occasions. The Allahabad High Court held that as the mosque is managed by the residents of police line exclusively, the mosque was a private mosque. So that was all for today. Hope you have understood all about mosques. We'll see you soon with a new topic. Till then, take care of yourself. Goodbye.